Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. I'm your host, Jordan Goewey, joined again today by Parker Baker, my fellow attorney here at Thomas Fisher and Edwards in Greenville, South Carolina. Parker, thanks for joining me on the podcast again.
Yeah, thanks for having me.
And so, Parker, we've talked about a number of different topics in the past, and many of your topics have been business related. Today is actually going to be a pretty advanced estate planning topic. We're going to talk about the Delaware Tax Trap. And so that's something that probably sounds a lot cooler than it is, but it actually is cool if you enjoy saving taxes. And so that's something that we'll try to educate our listeners on today. So why don't you start off by just telling us what is the Delaware Tax Trap and why is it called a trap?
Yeah, so the Delaware Tax Trap is a provision in the Internal Revenue Code that essentially says when you exercise a certain power of appointment, a non-general power of appointment, and you do it in a special way so as to increase the time period that assets are held in trust, that will cause inclusion of those assets in your estate. As we'll talk about later, there's income tax reasons that we might want to do that. So the reason that it's called a trap is because it can be done inadvertently, and that can cause estate tax inclusion where you might not otherwise have wanted that.
Yeah, so let's kind of start with the bad side of things. So if someone is not careful about the way in which they're exercising a power of appointment, how can an estate planner mistakenly or accidentally trigger this trap?
Yeah, and so the reason, like we said, that this is a very complex topic is that there's a lot of interaction with state law. And I think in other states, it's typically easier. The reason it's called the Delaware Tax Trap is they had a special statute that made it much easier to inadvertently trigger this trap. In South Carolina, typically the way that would be done is if that first power, the one that we use to create a new power, if that was exercised to create a power that could be used to withdraw assets of the trust for the beneficiary, and that would inadvertently trigger the trap.
Yeah, and so let's take a step back then. To your point, I do think that with the way that state laws work, it's probably relatively difficult in a state like South Carolina to trigger it inadvertently. And so we really just look at this trap as a potential good thing if you know how to use it. And so if we just level set for a moment, there's probably a lot of financial advisors and other professionals who are listening to this podcast. And if they are, what sort of circumstances do we look to as being opportunities to trigger the trap? And then we'll talk in a moment about how to actually do that. But if we're just looking for the ideal opportunity to trigger the Delaware Tax Trap, what does that look like?
Yeah, so if you have an existing irrevocable trust agreement and you have a beneficiary that has a non-general power of appointment, if you have those things and you have appreciated assets within that trust and you have no estate tax concerns about the beneficiary, their assets are well below the exemption amount, then this can be a very powerful tool to force inclusion in their estate and get a basis step up at their death over those assets that you otherwise wouldn't get for those assets that would otherwise be outside of their estate.
Yeah, I think that's exactly the situation to look for. And I'll note that that's a situation that arises a lot at this point because current estate tax exemptions are $13.99 million. They're going up to $15 million next year, and we now have some certainty that they're going to stay high for the foreseeable future. And so with that in mind, there should be tons of trust that we and other estate planners set up years ago when estate tax exemptions were lower. Even just a simple credit shelter trust for a surviving spouse, where you have a few $1 million in that trust, but maybe the spouse doesn't have $15 million outside of the trust. And so you have these situations where there are these assets that are in a trust outside of that surviving spouse's estate or outside of another beneficiary's estate, and there's highly appreciated assets in that trust, and the beneficiary of the trust seemingly has plenty of estate tax exemption that we could include some assets in there. So I think that situation arises a lot. And so if that does come up, then how do we then go about actually triggering the trap in that situation?
Yeah. So essentially what we do is we take that limited power of appointment that that beneficiary has, and we exercise it, typically through a provision in their will, and we send those assets to a new trust. And what we give the beneficiaries of the new trust is essentially a full withdrawal power over the assets. That, for state law purposes, allows for the trust assets to stay in trust for a longer period of time, and that will trigger the trap, causing that estate tax inclusion for the exercise of that first power, and then getting that basis step up at the power holder's death.
You noted when you were setting up this example, Parker, one of the key things that you're looking for is that existing trust has an existing power of appointment in it, and specifically a limited power of appointment, a power of appointment that cannot be exercised in favor of the beneficiary or the beneficiary's creditors or the beneficiary's estate or the creditors of their estate. And so what if that power of appointment is not in that initial trust? Is there any way that we can add one or otherwise find a way to trigger the trap?
Yes, we can add one. I will note that it's probably not the technique that we would use if we were to go down this road. The way that we would do it is what's called a decanting. We pour the trust assets from the old trust into the new trust. And when we would do that, we could give a limited power of appointment that beneficiary could exercise to give the new beneficiaries that full withdrawal right that we just talked about. The reason we may not want to do that is because if we do a decanting, we can actually give the beneficiary a full general power of appointment, cause the same estate tax inclusion, cause the same basis step up, but not have to give a full withdrawal power to the beneficiaries of the new trust, which will allow those assets to stay in trust longer, stay protected longer.
That's a good point. So with the decanting, we have more flexibility. We could just add in the general power. And then crucially, we don't have to give that next generation, that next beneficiary, a full withdrawal power, because if it's a situation where it's that trust for surviving spouse and it's the credit shelter trust and they've got plenty of exemption and they're going to exercise it to leave assets to their adult children who they trust and who can manage assets, then it may be fine to leave those adult children that withdrawal power. But if it's a minor child or if it's a child who has some sort of compulsive behavior issue, then you may not want to leave them a full withdrawal power. And so that's a limitation of the trap. And so through a decanting and adding a general power with more flexibility, there is maybe benefits to doing the decanting. So with that in mind, why wouldn't we just always do the decanting? Why is it still nice to have the Delaware Tax Trap as an option?
For one, it's much simpler than doing a decanting. We don't have to draft a new trust agreement. There's less administrative complexity. We don't have to find a trustee to be able to do the decanting for us. In some instances, institutional trustees have some concern about doing some of these decantings. And because of that, it's much simpler just to use the beneficiary's will to exercise the power in this way. It's much simpler, it's much cheaper, and it can also be done much faster. So if you were to identify a situation where there's a beneficiary and that beneficiary may be passing away soon, that's something that we can get in there very, very quickly and give them that special power to cause the estate tax inclusion. So I know that you and Randy have done that for a client before.
Yeah, certainly. And that's something that we've done a number of times here at the firm. It's something that I do think can be done very quickly as long as that person has capacity to execute a new will, or even just a simple codicil to their will can be enough to accomplish exercising that power. We prefer to be able to do it in a way in which we're exercising the power and we're probably still involving their revocable trust and maybe leaving assets to a separate trust that kind of segregates those assets and has specific provisions in it. But if we needed to do it very quickly in a 1 or 2 page codicil, we can do it in a way to accomplish the goal of getting that basis step up upon the death of someone. And so I do agree that it's a complex technique, but it can be done very simply from a document standpoint and from a time standpoint. And for that reason, there are benefits to having it, even though a decanting or a court modification to add a general power of appointment may have more flexibility and may have a broader range of positive outcomes that we can create. And so, again, Parker, I know this is a complex topic, but it is one that I want us to be able to make people aware of so that they can find opportunities for us to use this, because it really can lead to substantial tax savings. So what is the one bit of practical advice that you would have for someone who is listening to this podcast if they have these opportunities arise?
What I would say is, first, you're going to want to identify the beneficiary of an irrevocable trust. Second, you're going to want to make sure that they have that limited power of appointment. If not, we can also talk about maybe the decanting idea that we talked about. But if they do have that limited power of appointment, we can do this Delaware Tax Trap idea. Where does it make sense? If you have appreciated assets in the estate, that would be great to get a basis step up over, and you otherwise have enough exemption for that beneficiary to be able to include those in their estate without causing estate tax. So how many assets, what's the value of the assets in the trust, and what are the value of their other assets versus how much exemption do they have?
Yeah, no, I think that's very practical and something to look for. And I'll just say, on just a more general level as well, this is something that's probably going to be a theme across this podcast and many future episodes. And it's something that I'm probably going to speak at the bar convention next year on as well. And it's a thing that's kind of been in my mind for a little while, which is that income tax planning is the new estate tax planning. And so I think anyone that holds themselves out as an estate planner, whether that be as a financial advisor, whether that be as an attorney, but if you're involved in estate planning, then the days of just thinking about estate taxes are kind of over at this point, and really have been for some time, going back to the 2017 Act that doubled exemptions. But now, especially that we have these permanent exemptions being so high, are relatively few people who are going to pay estate taxes. So if you're advising people on estate planning and you're also going to be advising them from a tax standpoint, then I really think that income tax planning and finding ways to incorporate income tax planning into an estate plan is very important. And I think that the Delaware Tax Trap is a great way to do that for many of these existing trusts. So Parker, thanks for coming on today and talking to us about this topic. And I look forward to having you on future episodes of the podcast.
Yep. Thank you, Jordan.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.